Africa is entering a retrenchment season as it grapples with the impact of the coronavirus lockdown, and that's according to law firm Cliffe Dekker Hofmeyr. Companies are being expected to enter large-scale retrenchments as more businesses buckle under the economic pressure of COVID-19. When can an employer actually introduce voluntary severance packages, and what happens when an employer simply can't pay these voluntary severance packages? Well, to speak to us a bit more about this and I guess give us a general understanding of retrenchments, we're joined by Thabang Rapuleng, who is a labor law expert and director at Cliffe Dekker Hofmeyr. He joins us now via our Skype line in Johannesburg. Thabang, thanks for your time and welcome to the AM report. Perhaps let's start with some of those rhetorical questions I was asking in the intro. When can a company actually go ahead and start introducing severance packages? I mean, are there signs for employees to look out for in the run-up to that reality?
Okay. Well, maybe the position has recently developed in that the Labour Court has now confirmed that there is absolutely nothing wrong with the company asking employees to apply for voluntary retrenchment packages even before the Section 189 consultation has started. And that's quite a recent development. So what basically the position is currently is that you don't have to wait up until the consultation process in terms of Section 189 starts before you approach employees with an offer of a voluntary retrenchment packages. And obviously for employees, what to look out for, it's always better for those who are nearer to the retirement age in any event who will have to leave. But for those who know that they might not make it if, for example, an objective criteria such as last in, first out, LIFO is used, then it's something that is worth considering when the company presents such an option to you. Because in most cases, you'll find that the voluntary retrenchment packages will be sweetened. You won't get the minimum of the law, but in most cases, you'll find companies offering you more than what you will get if they were to retrench following the minimum prescriptions of the law.
And if you are affected by that process, a retrenchment process, or if you're given a voluntary severance package, how much can you as an employee demand for employers to be open about, I guess, where the business currently stands? I'm not sure if I'm making sense. How much information essentially can I demand as a worker if I'm in fact, affected by a retrenchment process?
Yeah. Well, if you are affected by the retrenchment process, I think the process itself, which is regulated by the Labour Relations Act, makes room for a consultation process where information can be requested from the employer party. And that information, obviously, it will be all the information that you deem to be necessary for you or the other consulting party to be in a position to make a decision as to whether a retrenchment is the last resort, is a means of last resort. But in a process of a voluntary retrenchment package that has been initiated before the formal consultation processes, in that process it will be now for the employee himself or herself putting their hands up for a voluntary retrenchment package. And if they require more details to be informed whether or not to take the package, they can request that information. But obviously as to what extent the information is relevant, it will differ from case to case.
And I wonder who decides that, but let's hone in a bit more on the consultations themselves. I mean, we've seen this play out at SOEs, largely because of, I guess, the noise made by some unions. I'm interested to find out what happens, for instance, for employees who don't have unions representing them. Who gets to fight in their corner in that instance?
Yes, in the consultation process, and in most cases, you'll find that employees will have unions representing them, but that's obviously for unionized employees and those employees that belong to those sectors. But in some cases where employees don't have union, what is advisable for the employees to do is for them to now group themselves and nominate amongst themselves representatives that can go and represent their interest at the consultation forum or the consultation table. And in some cases where you find that the number of employees affected is not a big number, the employer will consult with those particular employees directly. And I've had incidences where you find employees requesting to be assisted by lawyers. As much as the law does not provide for it, there is nothing that stops the employer from saying yes if they are comfortable with allowing legal representatives to be part of that particular process.
That's interesting. The reality, of course, is that not all companies will, in fact, be able to pay out severance packages, especially when you consider the fallout of COVID-19. There's the option of applying for, I think it's called a relief of some sort, an exemption, from government, at least as an employer. What does that process entail, and where does it leave workers?
Yeah, maybe the starting point is that paying a severance package is a legal obligation. It's what employers should do and should comply with. Particularly if one considers that at what stage do you pay a severance package? It's at the stage where now someone is losing their job and they will be without a salary going forward. So the severance package is meant to cushion that kind of a pain. But if an employer is genuinely in a position where they cannot pay a severance package, there is room for them to approach the Minister of Labour to apply to be exempted from that particular obligation. In my view and in my experience, it will be quite rare and exceptional for the Minister of Labour to agree to such, but obviously it's something that is available to employers to exercise, and those employers who are able to motivate as to why they cannot be able to meet that obligation of paying a severance package.
And where does that leave workers? Let's say, for argument's sake, the Labour Minister does grant the exemption. Must the workers just, I guess, accept that they've received the short end of the stick? I mean, at the face of it, that doesn't sound very just, at least to my ears. Yeah,
well, it does not mean by virtue that the minister has granted, the workers are left without a recourse. If the workers feel that the decision of the minister is one which is not fair, for example, the workers can still approach the legal tribunals, for example, the courts, in challenging the rationale of that particular decision, because in granting that, the minister will be exercising administrative powers and they are open to be challenged.